All right, this is 2509380M, the People versus Randall Crane. Are we ready on Randall Crane? Mr. Crane's coming up. Hey, you, Mr. Kazicki?
No.
Mr. Crane, do you have counsel? Was that you, Mr. Barron?
Your Honor, Todd Barrett. I did speak with Mr. Crane prior to the court calling the case today. I think that at this time, Mr. Crane's probably best served proceeding on his own. There are some constitutional arguments that he's raising that I don't think, as a member of the bar, I can.
Oh, is he a sovereign citizen?
He's making some sovereign arguments, yes.
Okay, I have very little patience for them. I will let you know that, sir. So, okay, tell me your name.
My name is Randall Crane. That's a living name, not a corporate fiction.
So you're a real person named Randall Crane.
Person. Okay.
Okay. No, listen to me, sir. You're here today because you have some charges against you. All right.
I'm challenging the court's jurisdiction.
Okay, well, denied. Your motion's denied. I have jurisdiction to the Constitution of the state of Michigan. What's your next? I'm not arguing with you, sir. I have jurisdiction. So
you have to provide subject matter jurisdiction as well as personal jurisdiction.
Your motion's denied. I have jurisdiction under the Constitution of the state of Michigan. What else? What else?
You do not have jurisdiction over the national.
I just said I did.
No, you don't.
All right. All right, so sir, do you want to proceed on these cases and talk to the prosecutor? Don't look on your phone while you're talking to me. If you
my notes are on.
No, you listen to me. If you don't know your sovereign citizen arguments well enough to come up here.
Welcome back to another wild day in court, and this one's pure chaos. Today, we're stepping inside Judge Shackleford's Michigan courtroom, where a self-proclaimed sovereign citizen named Randall Crane decides he's above the law. What starts as a routine hearing quickly spirals into a masterclass in courtroom delusion. You're about to see a man challenge the very idea of jurisdiction, reject legal counsel, and spoiler, walk himself straight into a contempt storm. But stay tuned, because this judge doesn't play games. If you ever wonder how not to represent yourself, Randall's about to give you a painful front row demonstration.
You're brought into court. You've already been arraigned. You have a charge of interfering with police officers in the while they're doing official business. That's a misdemeanor, punishable by up to 90 days in jail and a fine of up to $500. You also have a civil infraction for operating using a mobile electronic device, first offense while operating a motor vehicle, a charge of no proof of insurance. Those are both civil infractions. Civil infraction for no proof of or no registration in a motor vehicle. So those are the charges against you, sir. I'm going to tell you the rights that are actually real rights that you have in this court. You have a right to an attorney appointed at public expense if you are indigent without money to hire an attorney, and if the offense charge requires a minimum jail sentence or the court determines that it might sentence you to jail. The appointing authority will decide if you are indigent and appoint counsel if you are eligible. You may have to repay the expense for an appointed attorney. You may contest your ability to pay the ordered fees if the court attempts to collect any costs for an attorney, and the court must determine your ability to pay at that time. If you have a trial, you have the following rights. You have a right to, this is how trials work. You have a right to call witnesses to speak for you at trial, and you can get an order signed by the court to require witnesses to come to court. You have a right to see, hear, and question all witnesses against you at trial. You have a right to be a witness for yourself or to remain silent. If you chose not to be a witness on your own behalf, the prosecutor could not comment on your refusal to testify. Lastly, you have a right to be presumed innocent unless you are proven guilty beyond a reasonable doubt. If you enter a plea, obviously you'd be waiving those rights. You also have a right to be released on bond. Now, it looks like you previously stood mute on these charges, so you're here today for a pretrial. You have a few options, sir, under the law of the United States, the Constitution of the state of Michigan, and statutory law and court rules in the state of Michigan. You can either retain your own attorney to proceed on this case, or you can.
Here we go. The classic sovereign citizen starter pack. I'm not a corporate fiction. I'm a living man. It's like these folks pull their arguments straight from a YouTube rabbit hole. What Randall doesn't understand is Every word of that phrase has zero standing in court. Judges have heard 1,000 times, and always ends the same way: denied. Notice how Judge Shackleford doesn't even flinch. She cuts straight to the nonsense, grounding the case back in reality. Sovereign logic might work in TikTok comments, but in a Michigan courtroom, it's a one-way ticket to frustration.
Have a pretrial with the prosecutor directly and try and work out an agreement, or we can set it for a jury trial, okay? Those are your options. You can get an attorney, use a court appointed attorney, but you understand that attorneys have an obligation to follow the law and not make frivolous arguments, which is what you want to make today. And if an attorney makes those arguments on your behalf, I could sanction them. So no attorney on this green earth is going to come in and make the frivolous arguments you're making on your behalf. Or you can speak to the prosecutor, or we can just set it for a jury trial. Out of those, I don't want to hear it. I want you to pick out of those 4 options what you want to do. Hire an attorney, speak with court appointed attorney, talk directly to the prosecutor to work towards a resolution, or set a jury trial. Pick.
Let me ask you a question.
No, I asked you a question and I'm telling you to answer it.
And I have the right to understand my rights and understanding.
Sir,
exactly
here,
what-
can you hand him this form? These are your constitutional rights I just read to you. Why don't you have a seat? You have a seat, read your rights, and I'll call your
Your
case
Honor,
back up.
I am asking for you.
Have a seat right now, sir. If you
I
don't
read-
understand them, read them.
I move for this court to dismiss.
Have a seat.
Where is he? Okay, well, that might never happen, but, what was that guy's name on that file? Because I'm assuming did he leave?
Crane. He did.
Did he leave?
Randall
Well,
Crane.
he's big mad. Well, I need that file because I'm gonna give him a bench warrant. All right. All right. Are you okay, Amy?
Yeah.
I'm coming. I promise I'll get to you real.
RFK Jr. is correct. Fluoride in water has hardened a lot of brains.
I'm just, you know what? I know I should be more patient. I'm so tired of the sovereign citizen. All right, we're coming back up. This is 2509380M, the City of Taylor versus Randall Crane. Mr. Crane, you want to come back up?
At this point, Randall's throwing around subject matter jurisdiction like it's a magic password that opens legal immunity. The problem? He doesn't even know what it means. The judge has already clarified jurisdiction multiple times, but sovereign citizens love circular logic. If they keep repeating the word, maybe the law will disappear. Spoiler, it won't. Watch how Judge Shackleford balances authority and control here. She's done this dance before. Randall's pushing buttons, but the judge refuses to let chaos take over a courtroom. This is calm professionalism versus unshakable delusion in real time.
Mr. Crane, did you have a chance to go over your constitutional rights that I provided to you?
Yes, I understand my constitutional rights.
Okay, thank you, sir. So at this time, I gave you 4 options. Would you like to retain your own attorney? Would you like to speak with House counsel and have an appointed attorney? Would you like to meet directly with the prosecutor? Or would you like to set the matter for jury trial?
I'm going to be requesting for an order of change of venue.
Denied. Anything else? There's no basis for that, sir. So I'm asking you, we'll just set it for a jury trial, okay?
I have to understand everything in regards to my case.
Sir, I gave you your constitutional rights so that you could review them. I also gave you the attorney,
I understand that,
court-appointed attorney to go over those rights with. So I gave you an opportunity to understand your rights. I'm not going to entertain, listen, I'm not entertaining your sovereign citizen arguments because they're unfounded and they're not legal. There's no legal basis for them. So I'm not doing it. So now I'm asking you, out of the 4 choices I gave you, which one would you like to do?
I am required to understand every everything in regards to my case,
Okay.
including subject jurisdiction matters.
All right, well, you could do your
Personal
research. I'm setting this for a jury trial. We'll see you back for your jury trial on November 14th of 2025 at 9:00 a.m. I really recommend you retain an attorney prior to that date, sir, because I know I'm going to tell you what you're not going to do: waste the citizens of Taylor's time with your nonsensical arguments. You're going to come in. You're going to try your case. Again, if you want to talk to House Counsel, you could do so.
I'm not wasting the city of Taylor.
And here comes the educational part. Judge Shackleford does something incredible. She reads out Randall's actual constitutional rights. This is what a real legal process looks like. Not conspiracy jargon, but due process, transparency, and fairness. She even offers him counsel, bond, and the right to trial. Meanwhile, Randall sits there acting like this is a script from Lawful Rebellion 101. The contrast couldn't be clearer. One side grounded in law, the other in delusion. It's like watching reality itself debate with a YouTube comment section. And spoiler, reality always wins.
Screen name Samsung. There we got sound on Samsung. What is your name?
I'm Jonathan Wiggins.
Okay. Your ticket is 25RO03001. This is a speeding ticket that was issued on the 9th of May at about 1:30 in the morning. You're eastbound 11 Mile in Lafayette. You were cited 35 and a 30. You can admit or deny responsibility, or you can admit responsibility with an explanation. How do you wish to proceed?
Not guilty.
Raise your right hands, please. Do you swear or affirm that the testimony you're about to give in this matter will be the truth?
Yes.
Okay. The officer will testify first, please.
Your Honor, on the listed date and time, I was traveling eastbound on 11 Mile approaching Lafayette when I observed a black 2021 GMC Yukon traveling westbound on 11 Mile. Eastbound on 11 Mile when I activated my front moving opposite radar and got a reading at a 47 miles per hour in a 35 mile per hour zone. I also observed the vehicle moving at a very high rate of speed, and that's when I activated my radar. The radar was tested before and after my shift, and I am certified to operate radar, Your Honor.
Thank you. Mr. Wiggins? Sir?
You ready for? You want to hear my statement? Is what you say?
Yes.
Okay. I'm Jonathan Wiggins. I was coming home from work, 1:30. I take that route.
We've lost sound.
No, he froze.
He froze and we lost.
When the judge says have a seat right now, that's not a suggestion. That's your last warning. But Randall? He's still trying to move for dismissal like he's the star of his own courtroom fantasy film. At this point, the tension hits a breaking point. The judge's patience finally snaps, and she does what every judge does when a sovereign refuses to comply. Bench warrant. Randall just talked himself out of freedom. This moment perfectly captures why YouTube law never wins. He didn't just lose his case. He lost his chance to be taken seriously in a court of law.
Let's see if I can call.
Do we have a phone number?
We do.
Your Honor, I'd like to just to clarify something. I was traveling, I might have missaid something in my testimony, but I was traveling westbound. The vehicle was traveling eastbound on 11.
I don't know what happened, but it just cut off on me.
Yeah, but we got you back.
Okay.
So where it left off was you said you were on your way home from work?
Yeah, I get off at 1:15, and I take 11 Mile every day, and I know to do 35 miles an hour on 11 Mile Road and 45 miles an hour on Woodward. I don't have no reason to be racing up and down the street. I'm 60 years old. it was a car on the side of me when he was in front of us, facing us. And when he pulled me over, he said, "You know, you pulled me over for?" I say, "No, I don't." He was like, "Well, you were speeding." And I was like, "Well, it was two cars. We were side by side on the lane. So how was I speeding?" And he said, "I visually radared you at 47." And I said, "Excuse me?" And at first he didn't have a radar. When I read my ticket, it says that he used the radar. And then he said, "Well, I'm just going to give you a ticket for 1 to 5 over." I still take this route every day. I'm tiptoeing just to get to 75 so that I can get home. It's kids racing up and down Woodward and all type of sports cars. I'm not one of those, and I didn't like him.
That line, "I know I should be more patient," says it all. Judges see this every week. People who reject the system but still demand its protection. Shackleford's human moment shows how draining these cases can be. Behind the robe is someone juggling real cases while trying not to lose composure at endless pseudo-legal gibberish. And honestly, she's earned the right to vent. Fluoride-hardened brains might sound harsh, but after hours of sovereign speeches, you'd probably say the same. This is courtroom fatigue, delivered with just the right amount of sass.
1 to 5 over, was it like that?
Yeah. That appears to be the case.
I'm a good driver, Your Honor, and
Yeah. I'm not saying you're a good driver.
I don't want to be
Civil
punished.
infractions are not crimes. Civil infractions are mistakes. They don't involve an intent to do evil. If somebody's just driving down the street, it's not unusual that they could be speeding because the speed limit's
Very.
set low. And if you're in a speed zone that's 25 or 30, and you're not thinking about your speed, you're just going from point A to point B, most of us could well be going faster than 30. Now, your speed was measured at 47 before the officer turned around to get behind you.
Allegedly.
Measured as you approached the officer.
He said he had it on radar, sir. He should be able to present that. I mean, he told me
That's not the way radar works.
he told me he clocked me visually.
He told you that he measured your speed with the radar because he observed you to be speeding. That's what motivated him to operate the radar, to use the radar device to measure the speed of your vehicle.
He told me he visually clocked me at 40. But
Okay.
it's okay.
That's not the you're taking things out of context. If an officer sees a vehicle approaching and thinks that it's going faster than the speed limit, they're trained. They can give a visual approximation that is going to be pretty darn close. Research indicates that the visual observation speed, not with a radar, but made by an officer, is going to be about 2 miles an hour slower than the car is actually going. But the point is, the officer thought you were speeding. He didn't cite you for what he thought you were going. He operated the radar so as to measure the speed, and he found that you're going 47. You've got a decent driving record, to say the least, and in the exercise of his discretion, he elected not to cite you for the full 3-point infraction, but he gave you a 1-point infraction. He knocked it down to a 1-point event. He's certified to operate radar. The radar unit was checked both before and after his shift. It worked at the start. It was still working at the end of his shift. It didn't break and fix itself some point in the middle. So there's no finding here that says that you were intentionally speeding, but I do believe you were going 47, and that means at least 35. So I do think you're responsible for 35 and 30. That is the speed limit there, 30 miles an hour.
Yes.
And the fine for that is $130. The $130 can be paid online or by mail, or you can pay it at the courthouse counter if you prefer.
Can I eliminate the points, Your Honor?
The points don't come from the court. They come from the Secretary of State. I can't change them.
And you say he checked his radar, not you, right?
Of course, I didn't check his radar. I
Okay.
don't know anything about radar.
He didn't have a radar, sir.
Yeah, he did.
He told me he did not use a radar. It
Oh,
was
that's
two
not
of
what he
us.
said. He said he
We
made a
were,
visual observation of the fact that you were speeding.
it
Then
was
he
two
used the radar.
cars. It was both of us. It was two
That doesn't mean
cars.
that either one wasn't speeding. If two cars are going the same speed, that means they're both going the same speed.
Yeah, so pull both of us over.
That's not practical.
Yeah, it is. I don't understand. I just know, you know what I really believe?
I
That
don't think I want to
he
hear.
got a chance to judge. And that's all I can say.
As he's driving in the opposite direction from you, he has no idea.
And he's back. Same script, same nonsense. Randall keeps circling back to, I need to understand everything. But what he really wants is control. The judge gives him every chance for options, all fair, all legal. Instead of picking one, he's fishing for loopholes that don't exist. You can see the fatigue setting in. The judge keeps composure, but her patience is running on fumes. When she sets the jury trial, it's over. This isn't justice delayed. It's justice determined. Shackleford just handed Randall the only thing that'll make him stop talking. A trial date.
That incurred significant travel expenses on the last day of the snowstorm here in Michigan. And potentially criminal activities has occurred because after I was unwilling to settle initially, someone in Waitrim made a false accusation on me, accusing me as a terrorist, trying to get me arrested. And the police report is available in Kent County Sheriff Office. And the CFS number is KSP-0123167167-2025. But of course, the prosecutors see the content is nonsense, so they decline to press the charge. And through this process of the bogus baseless attack to fabricate me as the terrorist, online stalking has occurred. So as an additional discouragement of further actions like that, because someone in Waitrim stalked me online, collecting information, and that includes...
Or may I respond?
Sure.
So I want to respond to each point made. First, Mr. Hodges, one, did not plead that he's a protected class, and two, there's no evidence obviously offered that he would be a protected class. There's nothing that would suggest that he was anything other than an at-will employee. Also not an at-will employee of Waitrim or Ms. Sheldon, who's the defendant in this case, which was just one of his remote supervisors. Two, he said he incurred travel expenses on the day that he was terminated. If he did, he was reimbursed for everything, and these proofs are in our papers, so that allegation does not hold any water. And three, the quote-unquote accusation of Mr. Hodges as a terrorist is not true. If you look at, I believe it's Exhibit 2, the Ms. Sheldon affidavit, Exhibit A to Ms. Sheldon's affidavit is a compilation that Wade Trim's Human Resources Department collected of Mr. Hodges' public LinkedIn comments that indicate that he is notorious for filing lawsuits and also has several threatening and violent comments against employers and supervisors and the like, which is why Mr. Hodges was reported to local law enforcement as Wade Trim's Human Resources Department was concerned for the safety of their employees.
So what did we just witness? A textbook example of why sovereign citizen tactics always backfire. Judge Shackleford remained calm, composed, and relentlessly factual, while Randall spiraled deeper into confusion. The moment he rejected real legal counsel, his fate was sealed. It's a reminder that courtroom drama might be entertaining, but the law doesn't bend to belief. Whether you're guilty or innocent, facts and procedure always win. If you found this case as wild as we did, hit that like button, drop your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns. Justice isn't just served, it's recorded live.